Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. 2 days back, Honorable Justice D.Y. Chandrachud and Justice J.B. Pardhiwala, 2 judges bench, while disposing the case of XYZ versus State of Madhya Pradesh. Other details not available. So, while disposing the case of XYZ versus State of MP, they dealt with the importance of dealing with the complaints of sexual harassment and sexual assaults in a sensitive manner. This is important word. Sensitive manner. Everybody should be sensitive towards the aspects. Why? Because with the sexual assault, definitely the victim will be traumatized. There will be so much of mental agony, mental distress, trauma will be there, she will be equipped to that. Suppose if the physical assault is there, you may escape some estimate, but it is a assault on the modesty, very serious issue. And in such cases, the judges, the police, they should show the so-called sensitivity. So please remember. Therefore, normally almost you may be knowing that in a case of rape, you know that the in-camera trial will be conducted. So now Justice G.Y. Chandrachud bench stated that hold in-camera trials not only for rape cases but also in sexual harassment cases. Please underline this. Previously only rape cases. Now even sexual harassment cases. Section 6, Section 8 already 376, even 354 also should be tried in camera. Right. First of all, basically the powers of the magistrate. So in section 327 it is clearly stated that court to be open. 327 I am sure. Let me see. Court to be open, yes. So the judge has to allow everybody because it's an open court. But at the same time, 327 clause 2, notwithstanding anything, the inquiry into or trial of a offence under section 376, 376A, B, C, and R. So this should be conducted in camera, right? So please remember, even in this subsection, if the magistrate thinks he can allow some person to access or he need not allow any other person also. Some persons may not be allowed during the trial also. The magistrate has got discretion. This is the power under section 327 CRPC. Right? Please remember, 327 clause 2 applies for in-camera trials. Now we will go to the facts of the case. Better you know. Actually, most of the cases, they arise out of the public interest litigations, out of the other aspects. Just like SC/ST judgment, Kashinath Mahajan. What happened? He was an inspection officer. He has written some notes and there it has caused SC/ST so much a problem. Normally, it is not a case relating to the abuse of SC/ST people. Likewise, here also, it's not a straight case. Right? Here what happened is, the appellant, that XYZ, since we should not disclose her name, she is a yoga instructor in a particular private university. It so happened that she felt that the university vice chancellor touched her inappropriately in March 2019, and she shouted at him. She cried or she shouted at him. She is a yoga instructor. She won't care anybody. Then as a result of which she was threatened with dismissal from the service. So therefore, she lodged a complaint in the police station. No action, no case was registered. She approached the superintendent of police twice, 2 times, but no action. What happens if you send the SP? Normally, it will be sent to the concerned SA, or concerned CA. So normally no action is here. Whatever it is, even though she approached the SP, no action was taken. Ultimately, the other go. Now we have discussed section 154 of the CRPC. So the police are destined to register a case. 154 clause 3 CRPC. It says that if the police do not register the FIR, you can approach the superintendent of police. That's also over. The alternative note, the third point is she has approached the court. She has filed a private complaint under section 156 clause 3 CRPC. Normally, it will be endorsed to the police for investigation. But here, it was not done. The magistrate, instead of endorsing it to the police, he wanted to take it on file under cognizance 199, section 200 CRPC. So he wanted to examine the complainant and also the witnesses. Here she came to the High Court. Of course, High Court also did not agree. Ultimately, she approached the Supreme Court. So please remember, because of the action of the magistrate in not forwarding the matter to the police, and because he asked the so-called complainant to produce her witnesses, and that he would record their statements, she was aggrieved. Normally, when once the charge sheet is filed, she will produce her witnesses, is it not? So this is the reverse thing happened. She suspected, and therefore she filed a revision petition SLP before the Honorable Supreme Court of India, right? So please remember, here GFCMC, of course, he asked her to produce her witnesses, and he wanted to examine them under section 200, and powers issue, process and delay is under section 201 CRPC, that right, postponement of the process. Then now you have to remember section 156 clause 3. 156 clause 3 says the judge may, not shall. Please remember, 156 clause 3 says whenever such case, private case is reported, no person, any magistrate empowered under section 190 may order such investigation. Here may. So therefore, judge may send it or may not send it. Here he did not send it. So this is the problem. Now, Supreme Court recognized that. Please remember, in such a case, the victim was already traumatized. Already I told you, traumatized. The court should not bend upon or should not go for the formulas, for the formalities of asking her to produce the witnesses. Simply, the police, it should have been forwarded to the police, right? So this was actually escalate her trauma, because bringing the witnesses, produce them before the court, all these things. Normally, it is the duty of the police when once the charge sheet is filed. Here, she has to prove her case before trial without being able to get evidence on record. So, JFMC or Judicial Master First Class should have exercised his jurisdiction to direct the police to investigate, which he has not done. Now, the Supreme Court has given guidelines. These are most important guidelines. Please, you have to remember all these guidelines. Number 1, allowing the in-camera whenever appropriate under section 327 CRPC. This is being done in the courts. Of course, all these guidelines are being followed in Ongole courts. As far as we are saying, whenever we go to the court, if an in-camera trial is there, the judge or the bench clerk will ask all of us to disperse away from the court, stating that the in-camera trial is there. Second point, allowing the installation of a screen to ensure that the victim need not see the accused while testifying, or ask the accused to leave the room when being testified. So this process is also being continued. We have been seeing, but that is a very transparent screen, because the other person should be able to hear, because you may be knowing, recording of the witness, I have told you, the evidence should be recorded in the presence of the accused person. So therefore, even though he is not seen, he has to hear. Therefore, it's a transparent screen. Third point, ensuring the counsel of advocate conducts the cross-examination in a respectful fashion and not asking about the history. Suppose even though the victim is a prostitute, you cannot go back into her history, and you have to ask her in a respectable fashion. And you should not, the advocate should not ask inappropriate questions. And another guideline is also given. I am not mentioning as point number 4, because the court also opined that it is better to give a questionnaire to the victim by the accused, by the advocate of the accused. Of course, it's not practical because spontaneously we have to cross-examine. Whatever she tells in the chief examination, then the cross-examination will be started, and then with the replies from her, it will be putting to a volley of cross-examination. But I think it's not practical. Whatever it is, if that point is also there. But I am not going to delve deep into that matter. So these three guidelines are compulsory, necessary, and it has been pointed out by the court time and again. So please remember, whenever you appear on behalf of the victim, on behalf of the accused, you have to mind these guidelines, and then only justice will be done to the victim who is already traumatized, who already having mental agony. You have to take it in a sensitive way. If you know this much, it is sufficient. I think already 10 minutes over. Thank you very much.